This is a cautionary tale about the risks associated with the international drug trade. Australian courts all too often deal with cases involving otherwise law-abiding people who are tempted to make easy money by bringing illicit drugs into this country. It appears that such people are chosen by international drug syndicates as they are seen to be less likely to arouse the attention of law enforcement officials charged with disrupting the importation of such drugs. As this case demonstrates, there is a real risk that anyone so tempted will be caught. Further, if they are caught, they will face a significant period in custody, and even when released, they will live with the consequences for the rest of their lives. The simple message that the court sends to anyone who may be so tempted is it's not worth it. Reda Raghay, you have pleaded guilty to one charge of importing a commercial quantity of a border-controlled drug, namely cocaine, contrary to the criminal code. The maximum penalty for the offence is life imprisonment. You're to be sentenced on the facts disclosed in the summary of prosecution opening for plea dated 1 October 2025, which I note is an agreed document. Starting then with the circumstances of the offending. At about 9:30am on 3 January 2025, you arrived at Melbourne Airport on a United Airlines flight from Los Angeles in the USA with a black Madison branded suitcase. At about 10:10am, your suitcase was examined by the Australian Border Force. You gave an incoming passenger card to officials, having answered no to the question, are you bringing into Australia goods that may be prohibited or subject to restriction such as illicit drugs? The card also contained the following details: that your country of residence was Switzerland, that your intended address in Australia was Meriton Suites, Melbourne, that you were travelling to Australia to visit friends and relatives and for a holiday, and that your emergency contact was Dominic Jones. When asked by officials if you packed all of your bags yourself, you answered yes. You agreed that you were fully aware of the contents of your bags. You told officials that you'd lost the key and forgotten the combination to the suitcase, and that you'd paid $200 for the overweight suitcase as you'd bought a lot of clothes in Las Vegas. You produced your iPhone from your pocket and provided the passcode on request. Shortly after, you told officials the following: that the suitcase did not belong to you and was given to you by a person in Los Angeles whom you did not know, that you did not know what was inside the suitcase and were to give the suitcase to someone who would approach you outside the airport, but you did not know who this person was, and you were contacted by a man named Dominic a week prior to travelling in Switzerland, who gave you $4,000 to purchase flights and accommodation. You spent a week in Las Vegas before travelling to Los Angeles, where you met the person who gave you the suitcase. The suitcase was examined by officials who located 21 black vacuum-sealed packages inside, half of which were wrapped in a towel. The vacuum-sealed packages weighed a total of 25 kilograms. A sample of white powder extracted from one of the packages was tested by ABF officials and returned a presumptive positive result for cocaine hydrochloride. You were arrested and interviewed by members of the Australian Federal Police. You told the police the following: that you were born in Geneva and live there currently, that in late 2024 you travelled from Geneva to Las Vegas sometime between Christmas and New Year, spent a week alone in Las Vegas before going on to LA. You had only been planning to travel to the United States for a couple of weeks and believed the reservation would be on your iPhone. You'd only travelled with a backpack. That you arrived in LA at about 1 p.m. on Wednesday the 1st of January and only stayed for a couple of hours. You departed LA on a flight to Australia at about 10:30 p.m. on the same day. When you got to LA, you didn't have a suitcase and stayed near the airport waiting for the plane. You told officers that you received the suitcase from a guy or guys you'd not met before next to the airport in LA. You walked there from the beach where you had been waiting. The guys did not tell you what was inside the suitcase. Everything was very confidential, no ask question, you told police. When asked why it was all confidential, you stated, I guess because this is the way he works. You did not ask the guys any questions when you received the luggage from them. You knew where to meet the guy because the guy gave you an address telling you where to meet. When you saw the man with the suitcase, he signalled with a hand sign like a wave. He told you to fly with the suitcase but didn't tell you why. After receiving the suitcase, you asked the man, wish me good luck, and he did so. He had given you a little money, which you had used to book flights and a hotel. Your flights from Geneva to Las Vegas, and Las Vegas to LA, and LA to Melbourne, and your hotel in Las Vegas were paid for with the money you received. You told officers that to get back to the airport in Los Angeles, you have to walk for 20 minutes and then take a bus. After returning to the airport, you checked in the suitcase and paid $200 because it was 7 kilos overweight. You were not able to open the suitcase because you did not have the pin for the lock. You were meant to give the suitcase to someone in Australia, but you did not know how they would recognise you. You told officers you didn't think about what was inside the suitcase, adding, less I know, better it is. You did not ask too many questions. You knew it was not something dangerous like a weapon or something. You thought maybe it was fake watches or something controversial. When ABF officials examined the suitcase and you saw the black parcels, you were scared. You were convinced to bring the suitcases for the free flights and a little bit of money. You were told there were no problems or risk. Finally, when shown your incoming passenger card, you stated that the emergency contact details are fake, that Dominic is your best friend in Switzerland, but the name Jones was made up. If I may be forgiven the use of a colloquial expression, aspects of this account simply do not add up. The white compressed powder found in your suitcase was forensically examined. It weighed 21,006.8 grams, that is a little over 21 kilograms. The purity of the powder was 71%. The total pure weight of cocaine in your suitcase was therefore 14,914.8 grams, or a little under 15 kilograms. Your iPhone was digitally analysed by law enforcement officials, and it contained the following: a WhatsApp chat with Rent Car on 2nd of January 2025, in which you said you would be in LA for 7 hours and asked for a car. Rent Car agreed you could have a car for $100 and agreed to arrange transport for you from the airport. You provided an address for the Hilton Los Angeles airport for the meeting. They agreed to meet you at 5:30 or 6 p.m. John Jones told you that before he gives you the suitcase, someone is going to ask for a password and that the password is Apple. John Jones subsequently directed you to Homewood Suites by Hilton and sent a screenshot of the location. You confirmed you'd arrived in a red Dodge and that you had given the person your clothes. You subsequently sent John Jones a copy of your passport and boarding pass. Your phone also contained a signal chat with Dom Falla, in which Dom Falla asked, "Where are you?" at 11:07 a.m. on 3 January 2025, shortly after you landed in Melbourne, and there are also screenshots of locations in Los Angeles. Turning then to the regime for sentencing. Importation of border control drugs is a federal offence. Section 16 capital A of the Crimes Act 1914 provides that in determining the sentence to be passed or the order to be made in respect of any person for a federal offence, a court must impose a sentence or make an order that is of a severity appropriate in all the circumstances of the offence. In making this determination, Section 16A(2) requires the court to take into account a broad range of matters, including but not limited to A, the nature and circumstances of the offence, F, the degree to which the person has shown contrition for the offence, G, if the person has pleaded guilty to the charge, J, specific deterrence, JA, general deterrence, K, adequate punishment, M, the character of the offender, N, the offender's prospects of rehabilitation, and P, the probable effect of the sentence on the offender's family. The legislature has not prescribed a hierarchy of sentencing considerations. All of these matters must be considered by the court to the extent that they are known to the court. I'll address each in turn, starting with the nature and circumstances of the offence. Both state and Commonwealth drug law sets various thresholds for drug-related offending. The seriousness of a given offence and the corresponding maximum penalty are determined by whether the offence before the court crosses one of those thresholds. Under Commonwealth law, there are two relevant thresholds for the offence of importing what the law describes as a border-controlled drug, such as cocaine. The first threshold is a marketable quantity, which in the case of cocaine is 2 grams. A person who imports a marketable quantity of cocaine into the country faces a maximum penalty of 10 years imprisonment. The second threshold is a commercial quantity. For cocaine, this is set at 2 kilograms. That is 1,000 times greater than the marketable quantity. Unlike Victorian law, federal law has no higher threshold of large commercial quantity. The 14,914 grams you imported represents 7.45 times the commercial quantity of cocaine. Considering that the importation of 2,000 grams attracts a maximum sentence of life imprisonment, this was obviously a very significant quantity of cocaine. If you were not caught, it would have ended up available for sale in Australia. In the case of Qua, the Victorian Court of Appeal referred to the quantity-based nature of the drug trafficking legislative regime and concluded that, other things being equal, an offence of large commercial quantity trafficking which involves a quantity representing multiples of the large commercial quantity threshold is more serious than an offence of commercial quantity trafficking which involves a quantity representing multiples of the commercial quantity threshold. Although the court was referring to Victorian law, the observation that the quantity of drugs that are trafficked or imported is an important consideration in an assessment of the seriousness of particular offending holds true for offending against the criminal code. It is, however, not the only determinant of seriousness. The role of the offender and what they stand to gain will also be relevant among other considerations. The quantity imported in this case, being several times over the commercial quantity, makes this a significant example of what is a very serious offence, being one which attracts a maximum sentence of life imprisonment. It is not alleged that you were involved in sourcing the drugs, nor is it part of the case that you were to play a role in the distribution of the drugs in Australia. Your role was effectively that of a courier, limited to collecting the suitcase in LA and travelling to Australia with the intention of handing it to an unknown person on arrival. While your role was therefore a fairly minor one in this international drug organisation, the drug trade cannot operate unless people like you are prepared to play their role. In this sense, people performing the function of couriers are an indispensable part of this heinous trade in human misery. Turning to your plea of guilty, a court will have regard to the timing of the plea, the strength of the prosecution case, and whether the plea at a late stage was a recognition of the inevitable rather than evidence of contrition or a real willingness to facilitate the course of justice. In this case, you entered an early plea of guilty. Your plea, I accept, is indicative of a preparedness to accept responsibility and is some evidence of remorse. The guilty plea has a significant utilitarian value as it saves the community the resources associated with your trial. It also saves witnesses the anxiety and inconvenience of giving evidence. You will receive a significant sentencing discount to reflect these matters. You were compliant and cooperated with police following your arrest. You participated in a recorded interview with the Australian Federal Police despite the absence of a French interpreter. You made some admissions during the interview. You subsequently considered the opportunity to provide further assistance, but declined to do so for fear of your life. Turning to matters personal to you, Mr. Raghay. You were born in Switzerland, lived there until the present offending. Your father died when you were 8 months old. You and your older brother were raised by your mother. During childhood, you were never exposed to violence, drugs, or alcohol. You come from a modest family. I note some members of your family are on the link observing proceedings today. Your mother works for the canteen at a school. You've reported no mental health issues. You do not drink other than socially, and you do not gamble. You did well at school. You completed an economics degree after high school and worked in a real estate agency whilst completing a real estate agent's course. You planned to complete your studies after your 1 year of compulsory military service in Switzerland. You are 22 years old and you have your whole life ahead of you. It is well established that when sentencing youthful offenders such as you, rehabilitation is usually far more important than general deterrence. This is because punishment may in fact lead to further offending. Thus, for example, individualised treatment focusing on rehabilitation is to be preferred. Rehabilitation benefits the community as well as the offender. However, the law makes an exception to this general principle in respect of very serious criminal offences, such as the importation of significant quantities of drugs. In such cases, even where the offender is young, general deterrence remains a highly significant sentencing consideration, as does protection of the community. The role of rehabilitation is correspondingly reduced, but not extinguished. You do not have any prior convictions, and I accept that you are of prior good character. This is relevant to your prospects of rehabilitation and reduces the need for specific deterrence to be achieved by the sentence imposed. However, as the New South Wales Court of Appeal in the case of Guardi's explained, it has been recognised that good character is not an unusual characteristic of persons who are involved at this level in this type of offending. It is not uncommon for persons who physically import drugs to be specifically selected for that task because of their blameless background, in the hope that the authorities will pay less attention to the venture which is being undertaken. It follows that the prior good character of a person involved in a drug importation offence is generally given less weight as a mitigating factor on sentence. The court must have regard to the probable effect that any sentence would have on any of the offender's family or dependents. In contrast to the position under Victorian law, there's no requirement for exceptional circumstances to be made out. Your family all live in Switzerland. You are clearly a much-loved member of your family. This is reflected in the many character references provided to the court as part of your counsel's comprehensive and very helpful submissions. They include references written by your mother, Ms. Raghay Hanane, a family friend, Jean-Marie Fernerod, your aunt, Ms. Mudad Miriam, and your brother, Adil Raghay. I've read each of these references. A number are very moving. They consistently describe you as a caring and respectful young man whose offending has shocked the writers. They describe the remorse and shame that you have displayed. Each of the writers asked the court to exercise mercy while recognising the seriousness of your offending. I have no doubt that your incarceration in Australia has been and will continue to be felt acutely by your family and friends who are unable to visit you due to the distance and expense of travelling to Australia. Other letters provided to the court by your counsel demonstrate that the recording of a conviction will have a deleterious effect on your future work prospects. Finally, there is your own letter of apology to the court, which I accept is heartfelt. In the letter, you inform the court that in a moment of poor judgment, you accepted a proposition whose full gravity you did not comprehend. You state that you had no intention of harming anyone, which I accept. You now understand that your action has contributed to what you describe as a network of suffering and destruction. You fully acknowledge the gravity of your actions and remain profoundly sorry for having participated in what you correctly describe as a trade that destroys life. Despite the seriousness of your offending, I assess your prospects of rehabilitation as very good. I take into account the support of your family, something that many people in this court do not enjoy, an impressive education and work history, your youth, and that you're not afflicted by mental health challenges or drug addiction. I've taken these matters into account in setting the head sentence and especially your non-parole period. Although the Crimes Act does not expressly require a court to take into account current sentencing practices, the implicit requirement to do so is imposed on this court. Consistency of sentencing so that like cases are treated alike and different cases are treated differently is an important sentencing principle. Consistency in this regard is not synonymous with numerical equivalence, but means consistency in the application of relevant legal principles. Because sentencing is fact-based and all cases are different, a sentence imposed in another case gives rise to no binding precedent. This court, when sentencing an offender for a federal offence, must have regard to sentencing practices across the country. Comparable cases decided by the intermediate courts of appeal provide the most useful guidance to a sentencing judge in this respect. The prosecution provided the court with a table of cases said to be comparable to yours. Each involved a person who imported at least a commercial quantity of a border-controlled drug by air. I've read each of the cases and have been assisted by them in determining the appropriate sentence. Your counsel referred me to a further 10 decisions which have also been of assistance. Turning then to the court's consideration of the appropriate sentence in this case. While the offender before the court must be sentenced in light of their own unique circumstances, I've taken the cases to which the court has been referred into account in imposing sentence. It is significant that the quantity of the drugs imported relative to the commercial quantity for cocaine in this case exceeds the quantities imported in each of the cases cited by the prosecution, apart from the case of Lou. By your plea of guilty, you are taken to have known that you were importing border-controlled drugs into Australia. Although you were not the mastermind of the operation, as discussed earlier, you played a vital role in the importation. Without your willing involvement, the importation could not have occurred. The drugs you imported do untold damage to society, as this court regularly sees and as you now clearly recognise. You were motivated by financial gain, although the court cannot determine with any certainty what you actually stood to gain. Having said that, it is apparent that others within the organisation were to be the recipients of the bulk of the profits. I've taken into account in mitigation of sentence your early guilty plea, your previous good character, and your youth. I can only pass a sentence of imprisonment if, having considered all other available sentences, I'm satisfied that no other sentence is appropriate in all the circumstances of the case. In all the circumstances, as recognised by your own counsel, I have no alternative but to impose a term of imprisonment. In fixing the non-parole period, I must pay regard to Section 19 AKA of the Crimes Act. It sets out the purposes of parole as follows: A, the protection of the community; B, the rehabilitation of the offender; and C, the reintegration of the offender into the community. Take into account the maximum penalty, the seriousness of your offending, and the plea of guilty, and your personal circumstances and other matters in mitigation, the court makes the following orders. Mr. Raghay, could you please stand? For the offence of importing a commercial quantity of a border-controlled drug, you are convicted and sentenced to 8 years and 8 months imprisonment, with a non-parole period of 4 years and 10 months. The sentence commences today. I'm required to explain the impact of the order. The total effective sentence is 8 years and 8 months. but I have directed that you serve a minimum period of 4 years and 10 months before you become eligible for parole. Accordingly, you will be required to serve a minimum period of not less than 4 years and 10 months, less the 294 days that you have served since your remand. If you are then released on parole, a question over which this court has no control, the balance of your sentence will be served in the community, subject to the conditions of your parole and subject to any order for your deportation. Any such parole order may be amended or revoked, and if you fail without reasonable excuse to fulfil the conditions of your parole may be revoked and you may be ordered to serve the balance of your sentence in prison. Having come to the conclusion that I have no alternative but to impose a term of imprisonment, under Section 17A of the Crimes Act, I direct that my reasons for so finding be entered in the records of the court. Pursuant to Section 18 of the Sentencing Act, 1991 Victoria, I declare that you've served 294 days in custody, not including today, which is to be reckoned as time served in respect of the sentence the court imposes today. And finally, but for your plea of guilty, you would have been sentenced to 13 years imprisonment with a non-parole period of 7 years and 10 months. Ms Adams, is there anything I've neglected to address?
No, Your Honour.
No. And Ms Ellis, anything require clarification from your perspective?
No. Just on one thing, when Your Honour said that the offender was taken to have known that he was importing, is Your Honour making a finding that he knew it was drug, or is it a high degree of recklessness, as Your Honour said during the submission?
Excuse me for a moment.
When Your Honour referred to, Your Honour said you are taken to have known that you were importing drug.
The mental element, Ms Adams, is it recklessness or...?
It's recklessness, Your Honour, and the prosecution's position on the plea, and this was agreed, is that Mr Raghay was no more than reckless.
Yes.
I submitted he had a high degree of recklessness given the circumstances.
Yes. Thank you for that clarification, and thank you for raising that, Ms Ellis.
Thank
So,
you, Your Honour.
paragraph 63 will read, by your plea of guilty, you are taken to have been reckless as to whether you were importing border-controlled drugs into Australia.
Thank you, Your Honour.
Thank you for raising that.
Thank you.
All right. I thank counsel for their assistance in relation to this matter, and Mr Raghay can be taken back into custody, please.